आईए डिस्पोजल हो गया है ना, रॉन्गली
नहीं आईए डिस्पोजल
किसी में एलए केस है, किसी में एलआर केस है, तो सब एक है कि सब अलग है?
सब एक ही है। एलआर एंड लैंड रेफरेंस केसेस एंड एलए के लैंड एक्विजिशन केसेस।
केस नंबर सेम रहता है?
नहीं केस नंबर नहीं है। This has been decided which has been challenged under the order LR reference cases. That is annexed with the order. So those are all are LR cases.
इसमें some of them are LR cases, some of them are LA cases.
No. All of them are LR cases. LA cases when the land has been required, the case number is given. That is LA cases. But
ये
when
correction हो क्या है? देखिए क्या correction हो गया है?
include what is the LR case. This award in the award they are writing that it's LA case, but it's actually LR case. After reference to the court, we have challenged.
Correction हो क्या ऐसे आएगा तो हम लोग क्या समझेंगे?
We have challenged the order passed in LR cases, not in LA cases.
और ये एरर वहाँ से करेक्शन हो गया, ये सारा करेक्शन हो गया है। एलए केस सब जगह एलए करेक्टेड एलए केस, ये सारे के सारे एलए केस में करेक्शन हुआ है। वही नहीं, पूरा जजमेंट का करेक्शन है एलए केस का, हर एक केस को एलए केस कर दिया गया है।
वही गलत नहीं है वहाँ पर, गलत नहीं है, ऐसा तो होना नहीं चाहिए। That should be LR cases.
तो ये गलती हम कैसे, हमको समझ ही नहीं आ रहा।
हमारे भाई प्रेयर में सबमिशन विल बी ऑन द लाइट ऑफ जो ऑर्डर की 136 उसी बेसिस पे कर दिया जाए, अदरवाइज रॉन्ग तो दे हैव डन समथिंग। Altogether 15 cases have already been decided. Have the number, on what days their appeals have been decided. Total 15 appeals decided.
और आपने अपने मेमो ऑफ अपील में भी सबको एलए केस कर दिया। हाँ, एलए केस किया हुआ है सबको।
I'm just reading my notes. The first paragraph.
But ये first paragraph
Being
FA 154 का ऑर्डर पढ़ो।
नहीं, just being
FA 154 का करेंगे।
बल्कू दे दिया है।
क्या बोलना LR केस बोले LA केस
LR case बोले, LA case is something different. तो acquire हुआ था that time LA case was
बताइए
एलए और एलआर साथ ही साथ रिकॉर्ड में लिखा हुआ है, एलए और एलआर ही होना चाहिए।
LR होना चाहिए ना। The learned counsel for the parties have jointly submitted that all these cases arise out of land reference cases, and the nomenclature is LR case. They submit that they arise out of land acquisition case number 20 of 2004 filing, and the corresponding LR case are as under. First appeal number 152 of 2018 का LR case is 94 of 2012. 154 of 2018 का LR cases 72 of 2012. और बताइए नेक्स्ट फाइल दीजिए। (156) of 2018. LR cases 80 of 2012. Next. 160 का है 75 of 2012. LR case number 75 of 2012. Next. 161. कोई आगे किसी में पेंडिंग नहीं है ना?
all I
84 of 2012. LR case. 163 का LR cases 240 of 2012. 166 का LR केस है 99 of 2012. 167 का LR केस है 77 of 2012. 169 का LR केस है 87 of 2012. 170 का corresponding LR केस है इसमें करेक्शन होके आया है LA केस, इसमें भी आया है।
actually कोर्ट का नाम को करेक्शन के गया था और they have changed the number again, case number. It has been sent to the lower court for correction of the name of the PO, designation of the PO. For that purpose it was sent.
तो रिकॉर्ड चेक करके ना करेक्शन LR केस लिखिएगा 88 of 2000. और 76 का रिकॉर्ड है तो 176 इसमें भी लैंड रेफरेंस केसेस में तो कोई डिफेक्ट है ही नहीं इसमें। सब इलाज केस में ऐसा कोई डिफेक्ट है ही नहीं। The learned counsel for the parties have also submitted that the present cases are covered by the judgment passed by this court. The appellants are aggrieved by the grant of compensation at less amount at the rate of 3,000 per display for all classes of land to the appellants. And the appellants have preferred these appeals for enhancement of compensation at the rate of 8,000 per display for all classes of land. They have jointly submitted that all the appeals arise out of the same land acquisition process with respect to the village Kadru, and identical issues are involved in all these cases. They have jointly submitted that. Baki the same.
Arising out of the same common.
It arises out of the same.
Common judgment.
ये डिक्री बनाने में इन दोनों में दिक्कत हो जाती है। कोर्ट बोलेगा, वो डिक्री बनाने वाला बोलेगा कि इसमें तो एक केस लिखा।
Is it apparently error? Because land acquisition start, not subsequently the reference.
Reference LR case.
Yes. Earlier also we have, I have found counter in this current case.
LR case. The learned counsels have also submitted that in the Leaf case which was decided by this court, which is FA number 176 of 2018,
On dated 25 March 2020.
which was decided on 25/3/2025, no such office defect was pointed out in connection with the nomenclature of the cases decided by the learned court, and same impugned order is involved in all the cases, in which the nomenclature has been mentioned as LR cases and not LA cases. He submits that out of the batch, in only 2 cases, there has been a defect regarding nomenclature, and it appears that the nomenclature has been changed by the learned court by correcting the judgment and award and it has been mentioned as LA case number instead of LR case number. They jointly submit that the case arises out of reference and the correct nomenclature is LR case number and not LA case number. And accordingly they submit that it be recorded that in FA number 154 of 2018 and FA number 170 of 2018, the nomenclature of the case decided by the learned court would be LR case and not LA case. Correct?
Yes.
Accordingly, it is observed that the nomenclature of all the cases which has been decided by the learned court by common judgment would be LR cases and not LA cases. And all the LR cases and a number of LR cases has been decided arising out of the same judgment in first appeal number 176 of 2018. ठीक है? इतना रहेगा तभी आपका डिक्री बनेगा. The office while preparing the decree shall take note of this aspect of the matter, and decree will be prepared in connection with LR cases and not LA cases. So disposed of
in the light of
FA 154, the judgment and decree which has been enclosed along with it is an LR case.
अरे आपका ऑफिस का ऑब्जेक्शन आया है, करेक्शन करने के लिए गया हुआ है, वहाँ पे करेक्शन होकर भी वैसा ही आ गया. क्या बोलेंगे? ऑर्डर में इस तरह से करेक्शन होकर आ गया है, तो हम कुछ बोल नहीं सकते ना, इसमें क्या ही बोलेंगे. ऐसा कोई तो मतलब रिकॉर्ड जो हम लोग के पास है उसमें भी ऐसा तो कुछ नहीं दिख रहा है.
मेरा
सब तो LR केस. सेक्शन 18 के रेफरेंस में डिसाइड हुआ है ना. तो रेफरेंस ही होता है ना सेक्शन 18. LR केस ही होता है.
इम्प्यून ऑर्डर में भी LR नहीं लिखा हुआ. जो इम्प्यून ऑर्डर है
अरे भाई दो केस में ऑफिस डिफेक्ट था, वो जाके LA केस कर दिया.
वो गलत हुआ है. LR ही होना चाहिए. बहुत सारे केसेस डिसाइड हो चुका है.
ये दोनों रिकॉर्ड है ना, और साथ में ये 76 वाला रिकॉर्ड निकाल के जरा उन लोगों को बुला के पूछे, जैसे सिलेक्टिव किसी में है डिफेक्ट, किसी में ये डिफेक्ट नहीं है, इस तरह से कैसे होता है? केस नंबर हम लोग कैसे ऐसे चेंज करेंगे? इसमें नहीं है डिफेक्ट, ये जो 76 वाला रिकॉर्ड है इसमें नहीं है इस तरह का. ये 164 से बनाना है।
May I mention one matter?
This is not the name.
For hearing on order 41 to 11, item 46, second appeal 541 of 2016.
Some admitted appeal.
For respondent number 2 and 3, you have to take press steps. SC number 541 of 2016. As per the office note, the notice could not be delivered upon respondent number 2 and 3 as no such person resides in the given address. The learned counsel heard the appellant, praised God and is granted time till 3rd of November to take press steps for service of notice upon respondent number 2 and 3 at their present and correct address. The recusals be filed through speed post. Office to track speed post delivery. Post this case on 17th of under appropriate heading.
Item 47, second appeal 518 of 2017.
Yeah, please. It's a plaintiff second appeal judgment of affirmance lawsuit. Suit has been filed by the plaintiff for declaration of his right title interest and for cancellation of sale deed dated 23/1979 executed in favor of defendant number 124. The claim of the plaintiff is that the suit land, that is of khata number 1, comprising of several plots, was originally recorded in CS records of right in the name of Birgunath Sahai and Jagannath Sahai, half sale. Birgunath Sahai, your lordship, died issueless. Before his death, he executed a registered deed of gift dated 9/8/1940 in favor of the Harihar Prasad. Against which Jagannath Sahai filed a title suit number 30 of 1945, challenging that gift deed. That suit has been dismissed. Harihar Prasad died leaving behind two sons, Sambhu Saran and Vishnu Prasad. The case of the plaintiff is that the suit property was settled by the Jagannath Sahai, the half portion of the Rayat, and one of the son of Harihar Prasad, Sambhu Saran, in the year 1940. This is the case of the plaintiff. The defendant case is.
So what is the error in the judgment?
Both the court has hold that the plaintiff has not proved his right title interest over the suit property because the defendant is claiming that property from one Revati Raman Prasad, say also one of the settlee, and against which one suit has been filed, title suit number 1 of 1975. That suit has been dismissed, and the claim of the defendant on the basis of the settlee Revati Raman Prasad.
Formulate your point.
Lordship.
There are concurrent findings in connection with your this deed gift deed.
gift.
There is some adoption also.
The gift deed is exhibit to your lordship.
Yes.
That is the CC of the gift deed. The learned first appeared for that framing the issue.
You read from here. Page number 12 of the applicable.
Lord. Finding your lordship.
6 and 7 are the core issues.
6 and 7 are the core issues, your lordship.
Read it.
Finding your lordship. Point of determination number 1, whether the finding recorded by the learned lower court on issue number 6 and 7 are sustainable in the eye of law and fact. Admitted fact, it is admitted fact that land under Khata number 1 of village Changel, PS Chatra district, Hazaribagh, measuring an area of 37.21 acres was recorded in the last cadastral survey operation in the name of two ex-landlords, namely Virgul Nath Sahay and Jagannath Sahay, and both of had half and half share. The plaintiff in para 8 of the plaint has stated that registered deed of sale executed by Kishori Devi in favor of Dukhan Sahu to be dated 12/1956 and defendant number 15 also in para 6 of the written statement stated it to be dated 12/1956 while the said deed appeared to have been executed on 13/11/1956 exhibit A to B. Such inconsistency is being ignored. This is important. The plaintiff has sought for a degree of declaration of their title and confirmation of possession over the schedule C of the suit land and in alternative for recovery of possession if they are found displeasure during the pendency of the suit. The schedule C of the suit land is transferred under registered deed of sale dated 12/3/1979 by Reti Raman Prasad and Ramji Prasad in favor of the defendant. This is the case of the 1 to 4 appertaining to Khata number 1 and 41 of village Changel, PS Chatra district, Hazaribagh, acres of the land. Under Khata number 1 is plot number 491 area 1.0 acres, plot number 495 area 0.
These are the details.
These are the details of the land.
It is pleaded by the
It is pleaded by the plaintiff that there was disruption between Virgul Nath Sahay and Jagannath Sahay and as such, and each got 8 Hana half share in the land under Khata number 1 of the village Changel. But there is neither pleading nor evidence on behalf of the plaintiff as to whether in the said disruption some plots under Khata number 1 came in exclusive share and possession of the Virgul Nath Sahay and some plot under Khata number 1 came in exclusive share and possession of the
For
Jagannath.
partition, there is no evidence.
No evidence. Or both got half and half share in each and every plot under said Khata number 1. There is also neither pleading nor evidence on behalf of the plaintiff that if some plots under Khata number 1 came in exclusive share and possession of Virgul Nath Sahay and some plot under Khata number 1 came in exclusive share and possession of Jagannath Sahay, then which plot under Khata number 1 came in exclusive share and possession of Virgul Nath Sahay and which plot under Khata number 1 came in exclusive share and possession of the Jagannath Sahay. The plaintiff had pleaded that Virgul Nath Sahay had no issue and he transferred his share in favor of Hariyar Prasad by
Who is
gift.
Hariyar Prasad, the son of
He is not this.
third party?
He is the third party. That half share has been gifted by Virgul Nath Sahay in favor of the Hariyar Prasad
Prior to his death.
prior to his death. And on one of the son of the Hariyar Prasad से हम claim कर रहे, plaintiff claim कर रहे, जगन्नाथ साय से भी और the plaintiff have pleaded that the Virgul Nath had also transferred his share of the Hariyar Prasad by gift deed dated 9/8/1940. The said gift deed has been exhibited on behalf of the plaintiff as Exhibit 2. It appears from perusal of translated copy of this Exhibit 2. To Virgul Nath Sahay transfer his half share of land in Tawji number 28, Khevat number 2 of Moja, Changel district, Hazaribagh, and 3 decimal of land Moja, Dhanhara district, Sahabad. If the land under Khata number 1 of village Changel has already been partitioned between Virgul Nath Sahay and Jagannath Sahay, then a specific plot with boundary would have been transferred by Virgul Nath Sahay in favor of the Hariyar Prasad. But it had not been done so by him rather the transfer of his share. So the pleading of the plaintiff is that where the disruption between both ex-landlords is not substantiated by evidence. B. That as it may be, the plaintiffs are claiming title over Schedule C of the suit land by virtue of Hukunnama granted by the Jagannath Sahay and oral settlement made by Sambhu Saran, son of Hariyar Prasad, in which Some oral settlements were confirmed by him by granting hukumnama and rent received. The plaintiff have brought 3 hukumnama on record in which first hukumnama, that is Exhibit 3, as per translated copy of Exhibit 3.
Each of the hukumnama has been disputed. So your basis of the title is your hukumnama.
That has been
Those
settled.
hukumnama has been disbelieved. So how do you establish your title?
Due to the misconstruing, the gift deed executed by Virgu Nasahai in favor of the Harrier Prasad, and that one of the son of the Harrier Prasad has been settled in favor of the plaintiff. And the Revti, the
But the
defendant,
plaintiff, but these people are also claiming through hukumnama,
not
and all these hukumnamas have been disbelieved.
that has been.
So
But the defendant also claiming the suit land from the Revti Raman Prasad, he is also one of the settling.
you have to make out your own
Not
case now. You are claiming by way of hukumnama,
Not
and all
That-
these hukumnamas you have not been able to prove.
that has been settled by Jagannath Sahai and Sambhu Sahai.
Jagannath Sahai and Sambhu. So what question of person is nothing? You are claiming it by virtue of what deed? Are you claiming it by virtue of any deed?
No, not so.
You are claiming it by virtue of gift deed.
Hukumnama. That gift deed has been executed by Virgu Nasai, the recorded tenant, in favor of the Harrier Prasad, the father of the one of the settlers.
Okay. That gift deed was in favor of
Harrier Prasad.
executed.
It is an
by-
admitted fact the land was recorded.
That's right.
Not.
Okay. Executed by
Virgu Nasai.
and you are claiming as son of. You are claiming
I am claiming on the basis of the settlement
hukumnama issued by.
issued by one Jagannath Sahai, one of the recorded Rayat, and one of the son of Harrier Prasad.
Jagannath Sahai, he's another settler.
No, he is one of the recorded Rayat.
One of the recorded.
Rayat.
Right. Okay. Jagannath Sahai, one of them, one son of Harrier.
One son of Harrier.
Basically, you are claiming all these properties through hukumnama.
Hukumnama.
Issued in whose favor?
In favor of the plaintiff.
In favor of?
The plaintiff.
And a hukumnama issued by whom? All issued by Jagannath Sahai in favor of and son of Harrier Prasad.
Son of Harrier. That is there, your lordship.
That's right, but you have not proved these hukumnamas, and that the area is not matching, the plot numbers are not
There is no
matching.
partition between the Virgu Sahai and Jagannath Sahai. Half share was there.
There has been no partition
No partition.
between the two.
That land was, suit land was recorded in the name of Virgu Sahai and Jagannath Sahai, half portion, your lordship.
For the learned counsel appearing on behalf of the applicants. This appeal has been filed against the judgment and decree dated 30/6/2017, in bracket decree signed on 13/7/2017, passed by learned District Judge Woman 3 Chatra, whereby civil appeal number 17 of 2006 has been dismissed. The judgment of the trial court is dated 9/6/2006, with the bracket decree signed on 22/6/2006. passed by the Ministry at Chatra in title suit number 10 of 1991. The learned counsel for the appellant has submitted that the suit was dismissed and in first appeal the judgment was confirmed and therefore the plaintiff is the appellant before this court. He has submitted that it is an admitted fact that the land under Khata number 1 of village Chandgar, PS Chatra, district Hazaribagh, measuring an area of 37.21 acres was recorded in the last cadastral survey operation in the name of two ex-landlords, namely Bhigunath Sahai and Jagannath Sahai, and both had half and half share. It has also, the learned counsel further submits that the plaintiff is claiming the property through hukumnama executed by Jagannath Sahai and son of Hariyar Prasad. Hariyar Prasad is the person in whose name the property was gifted by way of registered gift dated 9/8/1940 by Bhigunath Sahai, who had no issue. It was also the case of the plaintiff that there has been partition between Bhigunath Sahai and Jagannath Sahai. The learned counsel submits that the plaintiff is claiming by way of hukumnama executed by Jagannath Sahai and one son of Hariyar Prasad. Who is Sambhu Sharan?
He is the son of one of the son of Hariyar Prasad.
Sambhu Sharan is one of the son of Hariyar Prasad. The learned counsel has submitted that these aspects of the matter have not been properly considered by the learned courts, and therefore a substantial question of law will be made. After hearing the learned counsel further, Pinat, this court finds that he has also submitted that the core issue involved in this case was in relation to issue number 6 and 7
6 and 7.
as framed by the learned first appellate court and the learned as framed by the learned trial court, and the learned first appellate court has considered the said issues as point of determination number 1. After hearing the learned counsel for the argument, this court finds that the following issues were framed by the learned trial court. ये appellate court का पेज नंबर 6 में पैरा नंबर 7 है. Both the parties led oral and documentary evidences. The learned trial court ultimately dismissed the suit. The learned first appellate court the plaintiff filed the appeal and the learned first appellate court framed the following points for determination. A cross objection was also filed by the defendants before the learned first appellate. While considering the first point for determination, the learned first appellate court recorded that it was not in dispute that the property was recorded in the name of the property under Khata number 1, area 37.21 acres was recorded in the cadastral survey in the name of two ex-landlords named Jugunath Sahai and Jagannath Sahai, and both had half and half share. One Kishori Devi, wife of Harihar Prasad, had executed registered sale deed in favor of Dukhan Sao on 12/1/1956, and the defendant number 15 However, the court also recorded that the registered deed is dated 13/11/1956 and not 12/1/1956. As such, inconsistency was ignored as the execution of registered deed was admitted. The plaintiff was seeking declaration of their title and confirmation of possession over Schedule C property, and in the alternative for recovery of possession if they are found dispossessed during the pendency. The Schedule C property was transferred under registered deed of sale dated 20/3/1979 by Revati Raman Prasad and Ramji Prasad in favor of defendant number 1 to 4 pertaining to Khata number 1 and 41. The details of the property has been mentioned in paragraph 24 of the independent judgment. The learned court recorded that it was pleaded that by the plaintiff that there was disruption between Raghunath Sahai and Jagannath Sahai and each got 8 anna share. And the khata number 1 of village Changar. But there was neither any pleading nor any evidence on behalf of the plaintiff as to whether in the same disruption some plot under khata number 1 came in exclusive possession of Raghunath Sahai and some plot in exclusive share of Jagannath Sahai, or both got half and half share in each and every plot under khata number 1. The court also recorded that there was neither any pleading nor any evidence on behalf of the plaintiff. If some of the plot under khata number 1 came in exclusive possession of Raghunath Sahai and some other plot of khata number 1 came in exclusive share and possession of Jagannath Sahai. The court also recorded that the plaintiff had pleaded that Raghunath Sahai had no issue and he transferred his share in favor of Harihar Prasad by deed of gift dated 9/8/1940 within bracket exhibit 2. The court took note of the translated copy of exhibit 2. Which disclosed that Raghunath Sahai transferred his half share in Todi number 28, Khewat number 2 of Mauza, Changar district, Hazaribagh, and 3 decimal land of Mauza, Dhangara district, Shahabad. The court recorded that if the land under khata number 1 of village Changar has already been partitioned between Raghunath Sahai and Jagannath Sahai, then specific plot number with boundary would have been transferred by Raghunath Sahai in favor of Harihar Prasad. But it was not done. The learned court disbelieved the pleading of the plaintiff that there was disruption between both the ex-landlords, as the same was not substantiated by evidence. The learned first appellate court thereafter took into consideration the various hukumnamas by virtue of which the plaintiffs were claiming title over the Schedule C suit property and rejected each of the hukumnamas by citing reasons. Paragraph page 14 appellate judgment. 14 and 15 completely. The learned first appellate court also discussed the other documentary evidences of the plaintiff, including the rent receipts as exhibited. And by citing reasons held that the Exhibit 1 series within bracket Exhibit 1 to Exhibit 1 by X as exhibited by the plaintiff did not prove even payment of rent on behalf of the plaintiffs with respect to the Schedule C property. The court also recorded that Exhibit 2, which is the registered deed of gift, one of the landlords, namely Vijnath Sahai, transferred his half share in Khata number 1 of Suk Moza, and another land in favor of Khalia Prasad. The deed of gift was challenged by Jagannath Sahai in title suit number 30 of 1945, but the suit was dismissed by Exhibit 6. And by this way, Exhibit 2 was recognized by a court of law. The learned first appellate court thereafter discussed the findings of the learned trial court and also other evidences based on record. The plea of adverse possession was rejected. By noting that the possession, if any, by the plaintiffs has not been peaceful. The learned first appellate court also recorded that the plaintiffs in paragraph 29 by way of summary as on 29 को the learned first appellate court has, by a detailed judgment, has concluded that the finding of the learned trial court that defendant number 1 to 4 have proved their title over the schedule C land the learned first appellate court also considered ये क्रॉस ऑब्जेक्शन है ना
Finding तो ये दिया हुआ है कि even though the defendant number 1 to 4 have also proved their title over the suit land is erroneous and not substantial.
तो उनका भी
उनका भी
नहीं।
but it is also held that the plaintiff has failed to prove his right title interest over the suit land.
The learned court held that the learned court also observed that the learned trial court, while adjudicating issue number 6 and 7, also recorded a finding that the defendant number 1 to 4 have proved their title and interest over the suit land. And considering the materials on record held that the conclusion of the learned trial court that the defendant number 1 to 4 have proved their title over the suit land, that is schedule C land, was not sustainable in the eyes of law. Thus, the learned trial court held that the learned first appellate court held that neither the plaintiff nor the defendant number 1 to 4 could prove the title over the supplier. The defendant number 15 had also exhibited certified copy of registered deed of sale dated 13/11/1956, which was marked Exhibit 1 in the series of defendant number 1 to 4, which was corrected by the learned first appellate court and was marked as Exhibit A-G. The defendant number 15 had also challenged the judgment and decree of the learned trial court in cross objection by asserting that the learned trial court ought to have held that the defendant number 15 had acquired right title and interest over Schedule A property. By virtue of the registered sale dated 13/11/1956. But the learned trial court had held that the defendant number 15 failed to prove the title over the land. The learned first appellate court recorded that the defendant number 15 had not filed the sale deed dated 13/11/1956 before the learned trial court, but had exhibited the same before the learned appellate court, which was marked as Exhibit A-G. And according to the pleadings of the defendant number 15, the land covered under Exhibit A-G was purchased by Jharkhand South, the maternal grandfather of the defendant number 15, from the wife of Hariyar Prasad. And after death of Jharkhand South, the defendant number 15 through his mother acquired title over the property. The court recorded that it was submitted by defendant number 15 that after death of Hariyar Prasad, his wife Kishori Devi inherited the land covered under the gift deed executed in favor of Hariyar Prasad by the ex-landlord Hurinath Sahai, but the recital in Exhibit A/G was contrary to the submission of defendant number 15. It was recorded that in the proceeding before the learned Munsif Zalibag in miscellaneous judicial case number 56 of 1948, bracket Exhibit 4/A, Jharkhand South had asserted that the land covered under the sale deed dated 12/11/1956 was settled in favor of Kishori Devi, wife of Hariyar Prasad, by Shambhu Sharan and Vikram Prasad, sons of Hariyar Prasad. And the court recorded that the contention of defendant number 15 was against the admission made by the predecessor in interest. And there was no evidence on behalf of defendant number 15 as to whether Hariyar Prasad died after coming into force of the Succession Act or before coming into force of the Act. The learned court thereafter recorded, after considering the materials, recorded that the learned trial court rightly gave a finding that the defendant number 15 has not been able to prove his title over the suit land. Further, the court also recorded that the defendant number 15 had although claimed his title over the land detailed in Schedule A of the written statement, but he had not filed any counterclaim before the learned trial court after paying proper court fees. And he was claiming a relief of declaration of his title over the land by way of cross objection, which was not tenable in the eyes of law. The learned court ultimately answered the point of determination by holding that although the learned trial court was right in recording finding that the plaintiff has failed to prove his title over the suit land, and the learned court was also right in recording a finding that the defendant number 15 has failed to prove his title over the suit land. But the finding of the learned court that defendant number 1 to 4 have proved their title over the suit land was also erroneous and not sustainable in the eyes of law. ये पेज नंबर 20 में है, सारा मार्क है, सारा कुछ appellate court judgments में है. The learned first appellate court ultimately dismissed the cross objection of respondent number और defendant number 15 है ना, respondent number 15 was defendant number 15. Of defendant number 15, who was respondent number 15 before the learned first appellate court. The operative portion of the judgment passed by the the second point for determination was answered as under. उसके बाद operating portion of the judgment passed by the first appellate court is also quoted as under. During the course of argument, the learned counsel for the appellant has not been able to point out any perversity in the matter of appreciation of evidence by the learned first appellate court. This court finds that the judgment is a well-reasoned judgment after considering every aspect of the matter and after appreciating the materials on record. This court finds no substantial question of law is involved in this case. Consequently, the opinion is dismissed.
Item 48, second appeal 32 of 2019.
The matter was adjourned by imposing cost on 2 occasions.
The direction to leave the copy. So I am in this case.
I cannot adjourn it.
हम कहाँ से
मतलब आपका 2 बार adjourn हो गया है मैटर, आपने
मैं
डिपॉजिट
सीनियर
कॉस्ट.
जस्ट टोल्ड मी कि फाइल नहीं मिल रहा है घर पर, सो काइंडली अगर हमें पेन ड्राइव में कॉपी दे दें.
देंगे ना कॉपी कॉस्ट के साथ, ऐसे नहीं देंगे, ऐसे नहीं देंगे, बिना कॉस्ट के कॉपी नहीं मिल सकती.
क्लाइंट बहुत पुअर है
आपने उसको और पुअर बनाया
और हम लोग के कॉन्ट्रैक्ट में भी बहुत महीने से नहीं है, मतलब लगभग 10
नहीं,
months
concurrent finding है।
तो और भी दुख की बात है कि उसने सारी उम्मीद छोड़ दी, आपसे कांटेक्ट करना भी बंद कर दिया.
ये बहुत ट्राई कर रहे हैं बट नहीं मिल पा रहे हैं.
वो जब फोन कर रहे होंगे तब केस नहीं ना
ये
परस्यू कर
एडवोकेट
रहे
कलर ने भी बहुत ट्राई कर रहे हैं, उनको भी बोला गया है कि आप ही एक बार क्लाइंट के
तो नो इंस्ट्रक्शंस बोल के डिसमिस कर देते हैं. यू डोंट वांट टू आर्ग्यू द केस. सेक्रेटरी बहस करने के लिए क्लाइंट का क्या जरूरत है? रिकॉर्ड चाहिए, रिकॉर्ड है. वकालतनामा चाहिए, वकालतनामा है. हम तो मानेंगे नहीं ना कि उनकी डेथ हो गई.
डॉक्यूमेंट्स के लिए उनसे
कौन से डॉक्यूमेंट्स? सारे डॉक्यूमेंट्स यहीं पर है जो है.
हमारे पास जो नहीं हमें
सारा डॉक्यूमेंट्स यहीं पे रहता है. ये कौन से अभी तो ऑर्डर 41 रूल 11 में है. देंगे आपको टाइम, कॉस्ट लगा कर देंगे. आपको इन्होंने बताया था कि टाइम मांग रहे हैं, इन्हीं को कॉस्ट दे दीजिए. हम लोग को नहीं चाहिए एडवोकेट लोग. आपका तो वैसे कोई काम नहीं है,
अभी जब तक एडमिट नहीं होता तब तक कोई नहीं है।
कॉस्ट देना पड़ेगा मैडम, ऐसे नहीं हम एडजर्न करेंगे। ऐसे नंबर 32 ऑफ 2019
DFT कर
यही लिखे the council for
क्योंकि
the
मेरे
appeal
को
submits that the
मैं
case be
सीनियर से
dismissed for default।
मैं अपने सीनियर से भी पूछ लेती हूँ कि इस तरह
पूछने का क्या बात है, आप जो बोलिएगा वही लिखाएंगे,
नहीं कॉस्ट की भी
यही लिखा देंगे that council for the appeal submits that the case be dismissed for default।
नहीं है फिर, क्योंकि वो तो मुझे ही फिर भरना पड़ेगा ना।
पढ़ना पड़ेगा, आप समझ रहे हैं आप क्या बोल रहे हैं?
नहीं अगर
आइडिया है
सीनियर तो मुझे ही बोलेंगे ना कि आप जाके वहाँ कॉस्ट लगवा दिए, तो फिर मैं क्या बोलूँगी, तो वो बोलेंगे आप ही दीजिए अपने पॉकेट से।
ऐसा आपके सीनियर बोल सकते हैं,
ये भी
बुला
हो
के
सकता
लेके आइए,
है, ये भी हो सकता
बुला के लेके आइए, नहीं तो अभी हम 1 लाख रुपए कॉस्ट करेंगे इसी
है।
ग्राउंड
ये वो तो बोलेंगे मुझे
दिखा देंगे। जूनियर काउंसिल यही बोल रहे हैं कि कॉस्ट जो है सीनियर मांगेंगे कि जूनियर को पेमेंट करना पड़ेगा।
अब मेरी तो उतनी आमदनी है नहीं, तो मैं क्या काम से दे पाऊंगी।
ये जो बोल रहे हैं सारा चीज वही लिखाएंगे, जितना जितना बात आप बोल रहे हैं सब चीज लिखाएंगे, लेकिन उनको सीनियर को लेके आइए। आज कोर्ट नहीं आए क्या?
आए तो थे फर्स्ट हाफ में, क्योंकि कोर्ट नंबर 9 में था केस।
उसका घर चले गए।
एक्चुअली उनके फादर भी इस पीरियड में उनके फादर भी बहुत अभी कंडीशन उतना अच्छा नहीं है, बार बार वो आईसीयू में
ये सब बातें जो है ना, आपने पहले तो नहीं बोला, आपने तो
मैसेज
कोई बात नहीं।
पहले भी
ऐसे
मैसेज
नंबर 32 ऑफ 2019 द लर्निंग, इसमें तो कोई एडवांस नोटिस नहीं है।
नहीं।
The learned counsel for the appellant seeks adjournment by stating that file has been dismissed. The no advance notice seeking adjournment has been circulated. The records of the case reveal that on earlier 2 occasions the case was adjourned at the request of the counsel for the appellant by upon deposit of 1,000 and then rupees 2,000 as cost. However, in order to give one more chance, the matter is adjourned and is directed to be posted on 3rd of November, subject to payment of cost of rupees 20,000 rupees to be deposited by the appellant or Advocate Clerk Association. The receipt regarding deposit should be filed by
Lordship, please.
30th of October, failing which this appeal shall stand dismissed without record. 20,000 रुपए जमा नहीं कराइएगा, अपने डिसमिस बोल रहे थे ना, डिसमिस फॉर डिफॉल्ट कर देने, वैसे ही हो।
मैं कहाँ से दे पाऊंगी 20,000?
कोई बात नहीं, डिसमिस फॉर डिफॉल्ट होने दीजिए, आपको क्यों चिंता है?
Item 49.
ऐसा आपके सीनियर बोल नहीं सकते हैं, कॉस्ट आपको देना पड़ेगा। आई डोंट बिलीव इट, अगली बार आएंगे तो पूछेंगे, आप भी रहिएगा साथ।
ठीक है।
Item 49, second April 73 of 2019.
Lordship, in this appeal, Lordship, the petitioner to the appellant has prayed for setting aside the appeal number 11 of 2010, judgment and decree dated 30/4/2010 and 14/5/2010, Lordship. Lordship, main crux of the point is, Lordship, that plaintiff had filed this suit for declaration of right, title and interest over the property of the Schedule A, and second, that the Schedule B property was the exclusive property of the plaintiff number 1, Stridhan, and she has acquired by her Stridhan, and also prayer was made for declaration and sitting for declaring that the deed of partition, which has been executed on 13/4/1992 is null and void, as on that date the husband of the plaintiff number 1 was hospitalized at Patna and he was not in a position to make his appear before the registering authority or to make it. Ultimately, Lordship, in the trial court, the entire suit was allowed in favor of the plaintiff,
And thereafter, Lordship may see the last portion, Lordship, of the title suit judgment, page 56. After examination of the witnesses, deposition of the documents exhibited, Lordship may see page 56. Although the title suit was allowed, but I am reading this to show only these things, Lordship. From second line, which has come to the side of plaintiff discloses that actually Amir Shah had not signed over the said
कहाँ
part.
से आप बच्चा आधा सेंटेंस पढ़ने
नहीं, page 56 title.
पेज 56 में है
हाँ.
कहाँ से पढ़े
Page 50 internal page है, so 16 पढ़ रहे हैं. Of the
कहाँ
title.
से पढ़े थे पूरा पेज है
अच्छा ऊपर से देखना है एलिस डॉक्यूमेंट.
हाँ ये आधा सेंटेंस तो पिछले से
हाँ ठीक है
सेंटेंस ये तो DW11 का एविडेंस का डिस्कशन
हाँ DW11 धुरंधर साहब में इसलिए इसी को पढ़ देते हैं यहाँ से पेज 55 इंटरनल पेज 50 से DW11 धुरंधर साहब in fact he is the son of the Kameswar Shah. Kameswar Shah has died during the course of the title suit and he was substituted by his sons. Dhurandhar Shah is defendant first party and he has stated that he is deposing for all defendants first party, but one defendant first party has given in writing that she admits plaint, that is the sister of the Kameswar Shah. She has admitted the plaint, Lordship, and against two other defendants first party suit has been taken ex party, so his evidence is self-contradictory. In fact, Lordship, Buddho Shah had three sons, Amar Shah, Jamahir Shah and Kameswar Shah. Jamahir Shah, second Shah, he filed a written statement admitting the claim of the statement made in the plaint, and Kameswar Shah died during the course of the title suit and he was substituted, and Dhurandhar Shah is the son of the Kameswar Shah. One of the sisters has also admitted the plaint which she has said. Ex parte, so his evidence is self-contradictory. This witness has stated the Schedule A property is of Buddhu Shah. On contrary to his own statement, he says that the Schedule A land was purchased by his father and uncle Amir Shah. So such type of witness cannot be believed. He has again stated that Schedule B land is in the name of Malwati, that is the plaintiff number 1, and has the wife of Amir Shah, and his father has not objected in this case. The defendant first party did not produce the original partition deed, so there could not have been proof of the Ellis signature of the Amir Shah over Ellis partition deed of the 1992. Not the Ellis identifier or testing witness was examined by the defendant first party to prove the Ellis signature of the Amir Shah over that partition deed. The defendant also has not lied the word in his written statement that the said partition deed is not in his possession or has been lost, and that case there was heavy onus to the defendant first party to prove the Ellis disputed signature of the Amir Shah over the partition deed. And two self-conflicting evidence of Jaikant Shah, and first one and which has come from the side of plaintiff disclosed. Jaikant Shah, he was the witness in the said partition deed. That actually Amir Shah had not signed over the said partition deed. The defendant first party has not filed any sheet of document to prove his Ellis claim that the suit property is joint land and there is partition of suit land in 1992. Also from the perusal of the exhibit shows in all such suits Amir Shah was a party and the defendants were not party. Amir Shah contested the suit and not the defendant, and defendant first party had no interest. The defendant second party, who is own brother of the Amir Shah and Kameswar Shah, has stated in his written statement that he admits the assertion is made in the plaint of the plaintiff, and one sister of present defendant first party Dhurandhar Shah and daughter of Kameswar Shah has also given in writing that she admits the contents of the plaint. This part is important. Defendant first party has also not made any counter claim in this suit, praying to cancel the sale deed disputed in favor of Malwati for Schedule B land. Defendants have not proved that Amir Shah used to look after all those affairs and fraudulently got the name of his wife in NSC. The defendant first party has stated that 13.4.92 Amir Shah came to Buddha court on Rissa and executed partition, but this fact has not been proved by defendant first party. From the aforesaid discussion of evidence on record, oral documentary opinion and findings thereto, and while dealing this issue, I arrived at the right conclusion that the partition deed dated 13.4.92 is void, illegal, and both fabricated and inoperative, and the defendant first party and second party have no right title interest over the suit land, and as reference Schedule B land, only the plaintiff number one of the right title claim. Accordingly, these issues are decided in favor of the plaintiff against the defendant first party, also defendant second party. Then next lordship, issue number 1, 2 and 6, it is worthwhile to mention that plaintiff got legal injury on dated 13/4/90 when it came to the knowledge regarding partition deed number 6-1. Then rightly the cause of action rose to file the suit and the suit is framed as maintaining the plaintiff are in relief. Lordship, against that order, the defendant preferred appeal, Lordship, and that is contained at page 12. Page 12. By virtue of the judgment passed in title suit, lordship, all the three claims and three leaves which were sought for by the plaintiff that has been allowed, but in this time making submission, in the appeal portion, lordship, the learned first appellate court has arrived at a finding that the Schedule A property was the joint family property, and with regard to the Schedule B property, it has been held that it was acquired by the Sridhan, so it belongs to plaintiff number one and her three daughters, and thereafter the deed of partition 13/4/92, it has been declared as null and void. So here the question is only with regard to the Schedule A property, which the defendants and defendant Dhurandhar Shah and appellant claiming that it is a joint family property. That is the main crux of the point, lordship.
And you are not concerned with Schedule B and Schedule C?
Schedule B, that has been declared in my favor and they have not preferred any appeal. So it has been confirmed. Schedule B,
So Schedule B is a self-acquired property.
Self-acquired property of the plaintiff.
This finding is in your favor.
Yes, lordship.
Right? And so far as partition deed is concerned, that has been held to be null and void.
Null and void.
This is also
in my favor, and the defendants have not preferred any appeal before against the Schedule B property and the deed of partition. So that is in my favor. Now the second appeal is only confined to the respect of Schedule A property.
Which says that it is not with respect to Schedule A property, there is concurrent finding.
Concurrent finding.
Concurrent finding? What is the finding of the learned trial court with regard to Schedule A property?
That I have read, lordship.
Yes, that is only in relation to Schedule A property.
Schedule A and others also. Because the learned trial court judgment is totally based upon the exhibits and the deposition made by the defendant witness number 11, Dhurandhar Shah. Dhurandhar Shah witnesses has been disbelieved on three grounds.
Where is the finding with regard to Schedule A property? Achha, okay. Defendant's plea in connection with Schedule A property has been rejected. But your title has not been declared.
What's the basis?
Is there any finding that you are the owner of Schedule A property by virtue of the trial court's judgment?
Trial court judgment, lordship, just I have read, lordship.
Yes.
Page 56, maybe see.
Page 56, we have seen it is 1992 about partitions.
From the aforesaid discussion of evidence on record, para 6 I am reading.
Yes.
Oral documentary opinion and findings thereto the whole while dealing the issue was arrive at right conclusion that the partition deed is void, illegal, forged, fabricated and inoperative, and the defendant first party and second party have no right title over the suit land, and as reference Schedule B land, only the plaintiff number one Manvati has right title claim for it. Accordingly, these issues there are lots of messy issues which they have been framed. Page 51 more, lordship. Page 51 running page internal page 11 of the title suit judgment. First, is the suit as framed maintainable? Have the plaintiff got any cause of action for the suit? Have the plaintiff got any right title and possession over the suit land? And fourth, is the registered deed of partition bearing number 611 dated 34 void, illegal, forged, fabricated, inoperative? 5. Have the defendant first party got any right title interest over the suit land by virtue of registered deed of partition on bearing number 611 and dated 34/92 to effect relief or relief? Point number, lordship, issue number 3, 4 and 5 that have been decided in favor of the plaintiff. Lordship may see the title appeal judgment. Internal running page, lordship, 13. First of all, para 2 MBD, it would be important to mention that the plaintiff had filed the original suit against Kameswar Singh and Jamahir Shah before the Court of Settlement of the Gurkha, where the same was registered as title suit number 24 of
कहाँ से
90,
पढ़े?
page 11, 13 देखा? Title appeal का judgment, internal page 2, page 13.
Internal page 13.
Internal, running page, and internal.
Internal page बोलिए ना,
Two,
आपका मैच नहीं
two,
होने का।
two. Internal page 2.
ये तो सबमिशंस वगैरह होगा ना?
हाँ सबमिशन वगैरह, तो इसको सबमिशन इसलिए बताना जरूरी है इसलिए कि इसमें जो बुद्धू शाह के जो 3 लड़के थे उसमें सेकंड सन जो है जमाहिर शाह, he has admitted the versions made in the plea, but he has not deposed, so court says his written, only filing or written statement will not serve the purpose. So main contesting defendant is the Kameswar Shah. Kameswar Shah died during the course of the trial of the suit, and he was substituted by his sons and daughters. One of the daughter of the Kameswar Shah, she had also admitted the plea. And Kameswar Shah's son, Dhurandhar Shah, defendant witness number 11, he is the main contesting respondent, defendant. Just to clear out the picture, Lordship, internal page 2, para 2 MBD. First of all, it would be important to mention here the plaintiff had filed the
ऐसे
original.
नहीं ना, आपका joint family property है, ठीक है? Joint family property में finding है. Show me that finding that it is a joint family property or it is not a joint family property. What do you want to say? That it is not a joint family property?
My contention is कि series of Lordship जो इसका findings है सो आया जाए यहाँ पर ले आते हैं. जो main finding है. Internal page 12, Lordship. Internal page 12. Para 19. First of all, I want to take up the substantial question number 1 and 2 together with the sake of convenient discussion of facts and law points involved in this substantial question as successes. 1. Whether the suit property mentioned in Schedule A of the claim is self-acquired property of husband of plaintiff number 1 as well as father of plaintiff number 2 to 4, namely Amir Shah, or the same is joint family property or ancestral property of both parties of this appeal. 2. Whether the suit property mentioned in Schedule B of the plaintiff is self-acquired Sridhan property of plaintiff number 1, Marvati Devi, or the same was acquired by Amir Shah in the name of wife Manvati Shah from the joint family. So far the issue number 2 has been, there is concurrent finding of both the courts, trial court and the appellate court, that it is valid and plaintiff number 1 has acquired it by still time. Now, with respect to the first substantial question, the learned counsel for the defendant number 1 party appellant argued the entire suit was acquired by Amir Shah from joint family fund as being karta of the family. All the family activities were being looked after by him as he was sole educated member of his family. But taking the advantage of illiteracy of his remaining brothers, he acquired entire suit property either in his name or the name of his wife Muhammad Manvati. But all the properties were in joint occupation of Amir Shah and Kameswar Shah, and when at the last time of his life, it was recognized by him that he has committed dishonest act with his brother, then the entire property was divided by him between those who registered deed of partition number 611 dated 13/4/92. That has been declared as void and illegal by both the trial court and the first appellate court lordship. So this contention of the defendant has been falsified. But the learned court below, without appreciating the oral and documentary evidence of the defendant, wrongly came to the conclusion that the defendant number 1 party have no right title possession over the suit property, and the sale deed of partition has also been wrongly declared as illegal despite of the fact that the plaintiff appellant have not dared to challenge the signature of the aforesaid Amir Shah. It was further argued that the learned court below has failed to appreciate the documentary evidence of the defendant in right perspective, and had the learned court below perused the exhibit C, C/1, exhibit D and D as a document 20. It was held the learned court to the property of civil joint family property. The reliance has been cleared. On the other hand, learned counsel for the plaintiff responded out the entire property of suit land has been acquired by Amir Shah from his own earning and income as he was posted as forester in Forest Department of State of Bihar, and it has also been pleaded by the defendant the said property has been acquired by Amir Shah from the joint family fund. as Karta of the family, thus the learned court below rightly held the right title and interest of the plaintiff over the suit land. It was further argued that the land of Schedule B is self-acquired property of plaintiff number one who has purchased the same from his freedom, and the same has rightly been recognized by the learned court below after appreciating the oral and documentary evidence for plaintiff. It was further argued that Amir Shah was patient of heart disease and he had never executed any deed of partition in favor of defendant number one, and a forged and fabricated deed of partition has been procured by the defendant number one, and even its original has not been produced before the court, and thus it has legally been held by the learned court because the said deed of partition is void document, and same does not require any interference by this court. Judgment to cite by jury. Now they have said, page 14, heard the argument advanced by counsel, learned counsel of both sides to peruse the oral documentary led by parties. During course of trial and find, it is admitted fact of both parties that one Buddhu Shah, that means he is the father of the Amir Shah, Jamir Shah, and Kameswar Shah. And plaintiff number one is the wife of Amir Shah, and plaintiff number 2 to 4 are daughters of the Amir Shah. Amir Shah, namely Musammat Manwati, and 3 daughters, namely Saraswati Devi, Sarvati Devi, Neelam Devi, are original plaintiff of the suit, who are at present respondent in this appeal. It would further be important to mention here that during the trial of the suit, Kameswar Shah died, and his legal representatives have been substituted in place, who are at present appellate of this appeal. Now, Lordship, the main crux of this appeal is to decide as to whether the suit property was acquired by the aforesaid Buddhu Shah during his lifetime, or the same has been acquired by Amir Shah from his own earning, or the same has been acquired by the aforesaid Amir Shah from the joint family fund. And to establish the aforesaid, both parties have led their oral and documentary evidence in support of their pleading. The original plaintiff number one, Manwati, has examined the PW1, and she has supported her pleadings in para 1 to 3 of her examination in chief by deposing that Buddhu Shah has 3 sons and partition took place among them 50 years ago. Her husband was posted in forest acquired land from Moja Rotra and Parsa from his own name. He has further deposed that while her husband was admitted at Patna hospital, a forged Batwara paper was prepared by the defendant, and the present case has been filed by her to declare the same as illegal. During cross-examination, she has further deposed in para 4 and 6 that land was acquired by her husband through registered deed, and he was separate from his brother since last 50 years, and a Panchayati paper was also prepared for the same. On the other hand, son of original defendant, namely Dhurandhar Shah, has been examined as DW11, and he is deposed in para 1 to 5 of testimony that the scheduled land of Sud Rotara and Parsa were acquired by his grandfather Buddhu Shah, and the land of Schedule B was purchased by his father and his uncle Amir Shah, as one of the uncle Jamahir Shah, has already been separated from his remaining 2 brothers, and his property has not been included in the suit. He has further deposed the land of Goda has been purchased after separation of Jamahir Shah from his remaining brothers. He has further deposed Amir Shah was Kapta of his family as he was eldest among the brothers. His father was less educated, and his entire family activities were managed by the aforesaid Amir Shah. Without entering into the remaining, this part is important, Lordship. Without entering into the remaining oral evidences of both sides, as per Order 41, Rule 31, Lordship, the learned appellate court was required to discuss all the evidences made by the witnesses, Lordship, but he has not done so. So there is a clear violation of Order 41, Rule 31 of the CPC. Without entering into remaining oral evidence, I want to peruse documentary evidence of the plaintiff for better appreciation of the appeal. An unregistered deed of partition has been executed as Exhibit 1 by A in favor of plaintiff, and having gone through, it appears that an unregistered deed of partition was prepared between Raghu Shah, son of Munshi Shah of village Parsa district Godda, and Amir Shah. He is the plaintiff's husband, Amir Shah. On 10 to 87, there is no whisper of the name of the other sons of the Buddhu Shah, defendants. Kameswar Shah का इसमें जिक्र भी नहीं है. In which it has been mentioned that both parties have acquired 18 kathas land of plot number 161, which is situated in Mojara Rotra through Kufa, and joint Jamabandi is still running, and descendants of heirs of both parties had already filed title suit number 18 of 63 before the second officer, and the same was decided on the basis of compromise. And hence, entire land is in possession of both sides, and thus, as per this partition, 9 kathas land of plot number 161 was allotted in favor of Amir Shah, and remaining 9 katha land allotted into the share of Professor Raghu Shah. So far the plot number 161 is concerned, there is clear findings that 9 katha was allotted in favor of Amir Shah, husband of plaintiff number 1, and 9 katha was allotted in share of Raghu Shah. Since this document has been marked in favor of plaintiff respondent, this question of genuineness of that document does not arise. Now, in continuation of aforesaid documents, I want to peruse Exhibit 1 and A and A by 1, unregistered deed of Tutnama, which has been marked on admission of both sides. Although it is an unregistered deed of document, but genuineness have not been challenged by the plaintiff, and hence there is no legal impediment to look into the recital of that document for better appreciation of this appeal. It would be important to mention this Kathy में किया था, that has been translated and it has been filed before the court. Now the Exhibit A, it appears that proofnama document was executed by one Hira Shah, son of Bhaju Shah of village Hanwara, in which it has been mentioned that his nearest relation is Bhutu Shah, son of Munshi Shah of village Parsa. As such, firstly he executed proofnama in favor of aforesaid Bhutu Shah, and thereby he withdraw his entire interest from the land of plot number 381, area 9 katha 42, plot number 489, 6 katha 92, plot number 484, 2 katha 92, 72, and plot number 285, 2 katha 22, total 1 bigha 12. Village Parsa, and accordingly the aforesaid land came into possession of the aforesaid Bhutu Shah, who was ancestor of both sides. If further
everything has been taken into consideration, there is no contest. All the documents and everything has been taken.
Lordship, my humble submission.
You say that you were a forester and therefore you had this self-acquired property. What evidence have you given? Did you take loan? You should have exhibited that you have taken loan, or you have taken money, you have taken out salary from your income. Nothing.
Lordship,
You have not produced any evidence.
Lordship, in fact, the land which has been
There was a compromise also in the earlier titles.
land has been mutated in the name of the Amir Shah.
Mutation से क्या होगा?
नहीं, ठीक है, mutation that doesn't confer any
That's
title,
nothing.
but
The
neither
partition,
partition.
the deed of partition has been disbelieved.
Deed of partition which was claimed by the defendant number 1, that has been declared as none and
That's
void.
right. So there is no partition.
Schedule P property has been declared in favor of the
That's right. You'll be happy with that.
Lordship, 3 points.
See, you being a government employee, you were supposed to prove the source of income. Did you prove your source of income? Show me one evidence regarding your source of income. One exhibit.
Lordship, so far the plot number 161 is concerned.
आपसे जो पूछ रहे हैं आप खाली इतना बताइए.
Yeah.
ये सेल्फ एक्वायर्ड प्रॉपर्टी आप बोल रहे हैं आपका है. Exhibit वो schedule A property. Correct? Show me one evidence.
One evidence to that effect, Lordship, out of his saving, plot number 161, there was a partition, there was a compromise between the two parties, and 9 kathas of land that come in favor of the share of the husband of the plaintiff.
Compromise in what?
Yes.
Compromise in what?
Compromise in look है unregistered deed of partition was prepared between Raghu Shah and
1992 ना?
हाँ.
What is disbelief of it?
इस under जो 13/4/92 का जो था deed of partition, that is the main lordship. When he was on deathbed, plaintiff number 1
That has been disbelieved.
That
The
has been
finding is in your favor.
Yes.
You don't worry about it.
Now,
Show me that this Schedule A property was your self-acquired property. Show me one evidence. What is the source of your income? Your only source of income was your salary.
salary.
Show us. What is the evidence?
That evidence has not been laid down, but lordship,
काफी है.
काफी
इससे कुछ नहीं
lordship, 3 substantial question involved होता है इसमें.
कोई substantial
नहीं,
question
इसमें
नहीं
खाली देखा जाए ना, थोड़ा सा substantial.
आपने कहा इसमें इतना देर से देख ही ले आधा घंटा से और कितना दे दे.
थोड़ा सा और देखा जाए ना, इसमें किसी का
कौन कितना देखता है?
नहीं,
आप हमको जरा बताइए.
नहीं, ठीक है, we are grateful कि lordship are giving a very patient hearing.
जब आपने claim किया है that you are a government servant and you claim that it is a self-acquired property, but you have not laid any evidence regarding your self-acquisition.
अच्छा, इसमें 3 पॉइंट है लॉर्डशिप, हम खाली बता देते हैं. व्हाट इज सब्सटेंशियल क्वेश्चन हुआ रोमन 6 में किए हैं कि in absence of any cogent evidence relating to पेज 6 में देखा जाए Roman 6 whether in absence of any cogent evidence relating to partition of Schedule A land, the claim of the plaintiff with respect to Schedule A property could have been disbelieved by the lower appellate court.
रोमन 6 का कुछ और ही
Roman 4, Roman 4, page 6. ये फर्स्ट है. Roman 1 देखा जाए.
नहीं आपका इस क्वेश्चन ही नहीं समझ रहा है, समझाइए.
Roman 4 का.
रोमन व्हाट इज इट?
Whether in absence of any cogent evidence relating to partition of Schedule A land, the claim of the plaintiff with respect to Schedule A property could have been disbelieved by the lower appellate court.
इस पे क्या?
इसलिए
You are claiming that Schedule A property is your self-acquired property.
self-acquired
तो
property,
उसके लिए पार्टीशन का एविडेंस क्यों चाहिए?
इसलिए पार्टीशन का चाहिए कि इवन इसका बुद्धू शाह है 3 sons, अमीर शाह, जमाहर शाह एंड कामेश्वर शाह. अब बुद्धू शाह का डेट हो गया 1944 में और उसके बाद जो इन लोग अपना प्रॉपर्टी जो किए हैं इस प्रॉपर्टी जो शेड्यूल ए का एक्वायर किए हैं इसमें पार्टीशन का कुछ हुआ ही नहीं है, इसलिए इसको जो क्लेम कर रहे हैं कामेश्वर शाह दैट इज रॉन्ग.
अरे भाई वो क्लेम कर रहे हैं कि पार्टीशन हुआ था इज रॉन्ग. फेयर इनफ. तो अगर पार्टीशन नहीं हुआ था तो ये कैसे डिराइव हो जाएगा कि आपका सेल्फ एक्वायर्ड प्रॉपर्टी है? सेल्फ एक्वायर्ड प्रॉपर्टी के लिए तो आपको प्रूव करना पड़ेगा ना इट इज योर सेल्फ एक्विजिशन.
अच्छा ये है ऑर्डर 41 रूल 31 का भी क्लियर एविडेंसेस नहीं है इसमें पूरा डिस्कशन नहीं है.
और कुछ आप ही बताइए, आपके पास तो प्रूव ही नहीं है दैट इट इज योर सेल्फ एक्वायर्ड प्रॉपर्टी.
इसमें थोड़ा सा जजमेंट खोजे थे इसका दिखा रहे हैं इसका दिखाएंगे ये
कॉन्करेंट फाइंडिंग्स में ना
कंकरेंट फाइंडिंग्स नहीं है इसमें फाइंडिंग ऑफ रिवर्सल है.
विद रिस्पेक्ट टू टू ना शेड्यूल 8 पर तो कॉन्करेंट है ना.
नहीं शेड्यूल ए पर कहाँ शेड्यूल ए में कंकरेंट फाइंडिंग नहीं है. ट्रायल कोर्ट का जजमेंट पे है कि हमारा क्लियर टाइटल है और अपीलेट कोर्ट है उसको रिवर्स किया है इन रिस्पेक्ट ऑफ शेड्यूल बी एंड डीड ऑफ पार्टीशन देयर इज कंकरेंट फाइंडिंग बट शेड्यूल ए में कंकरेंट फाइंडिंग नहीं है. ट्रायल कोर्ट मेरे फेवर में किया, अपीलेट कोर्ट उसको रिवर्स किया है. इसको तो इनको तो पूरा डिस्कशन करना चाहिए रिगार्डिंग ऑल द विटनेसेस डिपोजिशन ऑफ ऑल विटनेसेस.
कौन सा डिपोजिशन कंसीडर करते तो आपका जजमेंट पलट जाता वो बताइए ना. कोई तो एविडेंस बोलेंगे ना कि ये एविडेंस में ये चीज कंसीडर नहीं किया तो मटेरियल एविडेंस बोलते हैं नॉट ऑल द एविडेंस.
मटेरियल एविडेंस
एविडेंस
धुरंधर शाह का जो एविडेंस पर हुआ है लॉर्डशिप इसका पूरा देखा जाए इसी में तो होता है.
धुरंधर शाह has said that it was your self acquired property.
धुरंधर शाह ने यही तो कंटेस्ट किए हैं मेन ना ये तो यही बोले हैं.
आपका क्या एविडेंस है that it is your self acquired property? You are the plaintiff.
हाँ
You have to prove it.
तो प्लेटिक तो उसका
डिपेंडेंट का विटनेस से आपका केस नहीं प्रूव होगा.
नहीं होगा लेकिन प्लॉट नंबर 161 में जो कॉम्प्रोमाइज हुआ है और ये और थर्ड पॉइंट है कि जिसमें स्टाम्प ड्यूटी अंडर द सेक्शन 35 ऑफ द स्टाम्प्स एक्ट इंडियन स्टाम्प्स एक्ट अगर उसमें स्टाम्प ड्यूटी पे नहीं होती तो उसको एविडेंस में नहीं लिया जा सकता.
क्या चीज को एविडेंस में नहीं लिया जा सकता?
जो
कौन सा चीज ऐसा एविडेंस में नहीं लिया गया?
ये जो यहाँ पर जितना लिखे है ना
एग्जिबिट बताइए कौन सा एविडेंस में ले लिया गया टू होल्ड दैट इट इज नॉट योर सेल्फ एक्वायर्ड प्रॉपर्टी.
जो एग्जिबिट डी है टाइटल सूट नंबर 63 और 62 हीरा शाह एंड अमीर शाह. एग्जिबिट ए एक्सक्यूटर ऑफ प्रूफनामा. एग्जिबिट सी बाय 1 कॉम्प्रोमाइज हीरा शाह. ये एग्जिबिट सी जो टाइटल सूट का है ये सब तो पूरा एग्जिबिट हुआ है वहाँ पर विच वाज इन माय फेवर जो हम पढ़ के पूरा सुना है पेज इंटरनल पेज 15 एंड 16 में. तो सब
कौन सा कॉम्प्रोमाइज में ये प्रॉपर्टी आपका एलोकेट कीजिए.
ये देखा जा रहा है ये पेज इंटरनल पेज 15 देखा जाए of the appellate court judgment.
Good for now.
And third line से
कॉम्प्रोमाइज दिखाइए. कॉम्प्रोमाइज काम करें. आप कॉम्प्रोमाइज बोले आप कॉम्प्रोमाइज दिखाइए.
अब ये देखा जाए थर्ड लाइन से हम पढ़ रहे हैं. An unregistered deed of partition has been executed.
पार्टीशन नहीं कॉम्प्रोमाइज.
अब ये यहाँ देखा जाए ये
कॉम्प्रोमाइज दिखाइए.
in which it has been mentioned both parties have acquired 18 kathas land with plot number.
आप कॉम्प्रोमाइज का बात किए, कॉम्प्रोमाइज दिखाइए. शिफ्ट मत करिए एक बात से
नहीं रिसीव नहीं कर रहे हैं तो
बस कॉम्प्रोमाइज दिखाइए काम ये कॉम्प्रोमाइज आपके फेवर में
अब इसी में तो पढ़ रहे हैं ना लॉर्डशिप थ्रू प्रूफा जो है उसी के बाद एंड जॉइंट जमाबंदी स्टिल रनिंग एंड डिसेंडेंट्स ऑफ रेजर्स ऑफ बोथ पार्टीज ऑलरेडी फाइल्ड टाइटल सूट नंबर 18 ऑफ 1963 before the second the same was decided on the basis of compromise and hence entire land is in joint possession of both sides and thus as per this partition 9 kathas of land plot number 1 seat was allotted in favor of Amir Shah and remaining 9 kathas land allotted in the share of aforesaid Raghu Shah.
ये कौन सा पार्टीशन की बात कर रहे हैं एंड एज पर ऑफ दिस पार्टीशन व्हिच पार्टीशन
प्लॉट नंबर 161 का जो इन लोग का हुआ था
कौन सा पार्टीशन हुआ था वो पार्टीशन जो 1992 में हुआ था that is
92 का तो टोटली डिस्प्यूट हो गया तो नन एंड वॉइड डिक्लेयर हो ही गया है
पार्टीशन की बात कर रहे हैं व्हाट इज द डेट ऑफ पार्टीशन व्हाट इज द डॉक्यूमेंट ऑफ पार्टीशन
इसका लोअर कोर्ट रिकॉर्ड है जो पूरा मंगाना होगा तब इसको बता सकेंगे 1863 का है ये तो 3 पॉइंट्स है लॉर्डशिप की ऑर्डर 41 रूल 31 का देयर इज नन कंप्लायंस ऑफ ऑर्डर 41 रूल 31 बाय द एपीलेट कोर्ट फर्स्ट एपीलेट कोर्ट
कौन सा एविडेंस नहीं कंसीडर किया और किसका एविडेंस नहीं कंसीडर किया बताइए
जितना जो
कौन सा एविडेंस कंसीडर नहीं
इंटायर एविडेंस ऑफ
एंटायर
प्लेंटिफ
मतलब अब इतना लंबा जजमेंट है अच्छा इतना डॉक्यूमेंट्स का रेफरेंसेस है इतना क्रॉस एग्जामिनेशन इसका रेफरेंस है आप बोलते हैं एंटायर एविडेंस व्हाट डू यू मीन बाय एंटायर एविडेंस व्हिच एविडेंस हैज नॉट बीन कंसीडर्ड
उनको तो पूरा जो प्लेंटिफ PW1 क्या बोला PW2 उसको तो डिस्कस करना चाहिए था ना जो डॉक्यूमेंट्स हुआ तो उसको
कौन सा एविडेंस आपके लिए है इंपॉर्टेंट
एविडेंस मेरा PW1 का इंपॉर्टेंट है उसके बाद जो है सो
PW1 का एविडेंस नहीं कंसीडर किया है
कंसीडर किए हैं वेग कंसीडरेशन है
ये कंसीडरेशन इस तरह से कंसीडरेशन नहीं होगी you claim it is a self-acquired property you show me your evidence that it is self-acquired matter ends there is no evidence the court record says there is no evidence from your end that it is self-acquired show me one evidence I'll admit
In
one
fact,
evidence that it is a self-acquired property
Lordship may see the conduct of the defendant.
Conduct से
नहीं इसलिए बता रहे हैं 13/4/92 का जो deed of partition इन लोग किए that has been declared as null and void thereafter on 15/4/92 the husband of the plaintiff number 1 has died lordship so when he is no more in this world how they will reduce evidence to that effect कि कहाँ से लोन लिए कहाँ से किए but self acquired property means out of the earnings of the savings of the from the earnings of the husband of the plaintiff number 1 they had acquired it
ये तो बोलने से थोड़ी होता है
अब
प्रूव करना होता है
अब 35 में इंडियन स्टैम्प्स एक्ट में साफ होता है इंस्ट्रूमेंट नॉट ड्यूली स्टैम्प
कौन सा
इनएडमिसिबल
इंस्ट्रूमेंट नॉट ड्यूली स्टैम्प्ड
ये जो आपको दिखा रहे थे प्लॉट नंबर 161 और उसके बाद भी
प्लॉट
दिखा
नंबर 161 में स्टैम्प थोड़ी होता है कौन सा डॉक्यूमेंट इज अनस्टैम्प्ड व्हिच डॉक्यूमेंट इज अनस्टैम्प्ड जो डॉक्यूमेंट पे आप स्टैम्प की बात कर रहे हैं वो तो ऑलरेडी डिसबिलीव कर दिया है परमिशन सूट
तो 13/4/92 का जब डिसबिलीव हो गया जो उन लोग का आपसी डीड ऑफ
अगर
पार्टीशन
मान लीजिए किसी का इंटरनल बंटवारा डिसबिलीव हो गया तो इसका मतलब क्या हो गया कि वो सेल्फ एक्वायर्ड प्रॉपर्टी है इसका मतलब ये है इट कंटिन्यूज टू बी जॉइंट फैमिली प्रॉपर्टी if the defendant is claiming partition and that partition is disbelieved then under such circumstances it will not automatically become your self acquired property it will continue to be joint family property and you have to show and prove by cogent evidence that it was your self acquired property
and in fact let's see the defendant number also did not find any counter claim with regard
कोई
to the
जरूरत नहीं काउंटर क्लेम का आपका तो बस खाली शेड्यूल ए पर आपका केस है
Schedule A पर
सेल्फ
case
acquired
है।
property there is no evidence I am asking you time and again I will record this only that you have not been able to show any evidence with regard to acquisition of this
एविडेंस
property
टू दैट
by itself.
इफेक्ट लॉर्डशिप इंटरनल पेज 15 से जो मेरा शुरू होता है 16 तक है यही मेरा एविडेंस है
Pardon?
रिगार्डिंग एक्विजिशन ऑफ द शेड्यूल ए प्रॉपर्टी लेकिन फाइंडिंग ऑफ रिवर्सल लॉर्डशिप एक सब्सटेंशियल क्वेश्चन ऑफ लॉ तो
ऐसा कोई लॉ दिखाइए कि रिवर्सल में सब्सटेंशियल क्वेश्चन ऑफ लॉ ऑटोमेटिक हो जाता है उसी ग्राउंड पर एडमिट कर दीजिए ऐसा कोई लॉ दिखाइए कि रिवर्सल होने पर सब्सटेंशियल क्वेश्चन ऑफ लॉ ऑटोमेटिक बन जाए नहीं बनता है ना।
इसको थोड़ा सा देख लिया दो टू जजमेंट साइड पर ऑर्डर 41 रूल 31 पर है।
ये साइड करके क्या होगा, कम से कम 10 जजमेंट तो हम ही कर रिमांड करते हैं, लेकिन आपको बताना तो पड़ेगा ना। ऐसे ऑर्डर 41 रूल 31 बोलने से क्या ऑटोमेटिक रिमांड हो जाएगा मैटर।
नहीं ऑटोमेटिक नहीं रिमांड
फिर
होगा, मेन उसमें कंसीडरेशन है कि जितना भी अभी रिपीट कर रहे हैं उसी पॉइंट पर कि जितना भी डिपोजिशंस है एग्जीक्यूट है उसका सेपरेटली है, तो उनको डिस्कस करना चाहिए।
The learned counsel for the appellant has submitted that the present appeal is confined only with respect to Schedule A property,
शेड्यूल है property।
which the plaintiff claimed that it was his self-acquired property. The learned counsel has further submitted that so far as Schedule B property is concerned, the same was claimed to be the self-acquired property of plaintiff number
One husband of the plaintiff number 1
स्त्री धन वाला कौन सा?
शेड्यूल बी है।
शेड्यूल बी ना,
हाँ स्त्री धन वाला शेड्यूल बी
तो कौन है उसमें प्लेंटिफ?
प्लेंटिफ नंबर 1 मानवती देवी
Was the self-acquired property of the plaintiff number 1. He submits that the defendants had claimed that there was a partition by virtue of partition deed dated 13/4/1992, but the same was declared to be void, illegal, forged and fabricated by the learned client. He has referred to internal page 16 of the trial court judgment and has submitted that the partition deed was declared to be void and it was also declared that that defendant first party and second party have no right, title, interest over the suit land. And further that the Schedule B property was only the property of plaintiff number 1. The learned counsel has submitted that so far as the finding of the learned trial court with regard to partition deed dated 13/4/1992 and also with regard to Schedule B property, the same has been sustained by the learned first appellate court. the learned counsel has submitted that so far as the Schedule A property is concerned, the learned first appellate court has held the learned first appellate court has partly set aside the judgment passed by the learned trial court by holding that land of Schedule A property of the plaintiff is joint family property, and all the three sons of Buddhu Shah, namely Amir Shah, Jamir Shah and Kamleshwar Shah, being the legal heirs of Amir Shah,
Legal heirs of Buddhu Shah. Buddhu Shah had three sons, Amir, Jamahir and Kameshwar.
legal heirs of Buddhu Shah, namely Amir Shah, Jamahir Shah and Kamleshwar Shah, and being the legal heirs of Amir Shah, the plaintiffs, first party, have right, title and interest over the Schedule A property only to the extent of Amir Shah. The learned counsel has submitted that Amir Shah was a government employee.
Yes, sir. You are posted as a forester in the forest department. What
He was posted as a forester in forest department, and Schedule A property was his self-acquired property. It was by virtue of a registered deed. It was supported by a registered deed. Which registered deed? Exhibit number?
रजिस्टर्ड डीड नहीं है, ये डीड ऑफ ये लोग का जो कॉम्प्रोमाइज वगैरह हुआ था जिसको पढ़ के दिखाया वही
नहीं
हाँ
भाई सेल्फ एक्वायर्ड तो उनके नाम से रजिस्टर्ड डीड होगा ना?
रजिस्टर्ड बाय वर्च्यू ऑफ द टाइटल सूट जो हुआ था इन लोग के बीच में कॉम्प्रोमाइज हुआ था।
अगर आप सेल्फ एक्वायर्ड प्रॉपर्टी होगा तो ड्यूरिंग द सर्विस टेन्योर यू मस्ट हैव परचेज्ड इट फ्रॉम समबडी।
परचेज का
From whom did you purchase it?
परचेज का नहीं है, परचेज
The learned counsel upon a query of this court
लेकिन ये है कि
has submitted
कॉम्प्रोमाइज
that
पिटीशन से एक्वायर्ड किए थे।
has submitted that the Schedule A property was that there is no supporting registered deed in connection with purchase of Schedule A property, but the same was acquired by way of compromise.
कॉम्प्रोमाइज इन टाइटल सूट नंबर 18 of 63 पेज 15 में है।
In title suit number
18 of 1963
18 of 1963.
यस लॉर्डशिप। नेक्स्ट में है यहाँ पर टाइटल सूट नंबर 18 of 1963 and 63 of 1962
And also in title suit number 63 of 1962 and 100 of 1962.
यस लॉर्डशिप।
He submits that the reference has been made to these these aspects of the matter in paragraph 16 and 17 of the learned appellate court's judgment.
15 and 16
The 17 people.
15 16 yes lordship।
15 to 17.
Yes। यहाँ पर लिखते हैं पेज 17 में 7th line वर्ड है, but none of the documentary evidence has been during the trial from which it will be aforesaid Amir Shah had acquired the land of scheduled plate through registered sale deed. That is the finding of the appellate court.
There is another reference of title suit number 100 of 1960,
Yes.
which was filed by Meera Shah and others against Amit Shah. In the impugned judgment, he also submits that in the impugned judgment, it has been recorded that the plaintiff, that it was claimed that Amit Shah had purchased his property through his own income and earning as he was a forester in the forest department. But none of the documentary evidence has been adduced by the plaintiff during trial of the suit, from which it could be presumed that the aforesaid Amit Shah had acquired the land of Schedule A property of the plaintiff through registered sale deed in his name from his own income. And the court has further recorded that the defendants have succeeded to discharge their owners, that most of the suit property of Schedule A was acquired by Guddu Shah, father of Amit Shah, Zamir Shah and Kameshwar Shah, by deed of Khurfanama, Exhibit A and A by 1, which has been earlier given to him by father-in-law of Guddu Shah, namely Beljo Shah, at the time of his marriage, and later on a Khurfa document was executed by him for future reference. On the basis of the Khurfanama deed, most of the land of Schedule A of the plain came in possession of the aforesaid Amit Shah after death of his father, and he was the eldest amongst his brothers.
Mahir Shah support नहीं किए.
The learned counsel has submitted that the learned first appellate court has not properly appreciated the materials on record, and therefore the provision of Order 41/31 of CPC has not been satisfied. He has referred to the judgment passed by the Honorable Supreme Court reported in bracket 2010 bracket close 13 SSC 530, and also the judgment reported in bracket 2022 bracket close 3 SSC 90. However, during the course of argument, the learned counsel for the appellant has submitted that no title deed regarding purchase of land by Amit Shah has been exhibited before the learned court by the plaintiff. Correct?
Review records have been made.
उतना नहीं, title deed नहीं ना है,
नहीं.
registered deed.
लेकिन
And
review records will be
and
made.
Amit Shah never purchased the property by virtue of any registered deed in his name. Correct? Arguments concluded. Order is reserved. Post for judgment on 29th.
Section 35 तो इंडियन स्टैम्प्स एक्ट का थोड़ा सा जिक्र कर दिया जाएगा.
इसका क्या हम जिक्र करें?
इसमें
कौन से डॉक्यूमेंट में स्टैम्प लगाना?
अनरजिस्टर्ड डॉक्यूमेंट जो इसमें हुआ है इसी का कार्य है.
चलिए नेक्स्ट कौन?
यहाँ का जो आर्गुमेंट होता है ना, यूट्यूब में सब देखते रहते हैं.
देखना ही चाहिए ना?
देखता है सब पार्टी लोग जब बैठा है वहीं देख रहा
देखना ही
होगा.
चाहिए. स्टैम्प कौन से डॉक्यूमेंट में स्टैम्प लगाना था आपसे पूछ रहे हैं तो आप जवाब ही नहीं दे रहे हैं. तो क्या स्टैम्प एक्ट का है आपका आर्गुमेंट में बताइए.
For orders item 22, first appeal 47 of 2015.
हम तो चाहते हैं कि लिटिगेंट लोग देखें.
नहीं तुम देख रहा है.
देखना ही चाहिए, उनका अधिकार है देखने का. उनका लाइफ इज एट स्टेक. हाँ बताइए, आपका वो वाला मैटर कल रहेगा. आइए पे ऑर्डर करिए. आप ही का था ना मैटर सुबह. कोई और से? हाँ. हाँ बताइए क्या हुआ?
So notices are 12A, 12B, 14A.
क्या हुआ इसमें?
Says that it found the door of the house locked. As notice has been served by hanging the respective.
Recipient does not live there. किसका किसका नोटिस आ गया है?
12A, 12B and 14A.
12A, 12B, 14A. House locked by hanging. Speed post undelivered by saying that the recipient does not live there. नहीं रहते हैं। तब
Present character.
FA number 47 of 2015. The London Council for the Appellant has submitted that has prayed for and is allowed time till 31st of October to take fresh steps for service of notice upon respondent number 12A, 12B, 14A at their present and correct address. For which requisites under speed post defined. और बताइए क्या है आपका सब्स्टिट्यूशन में भी डिफेक्ट?
फर्दर जो है उसमें कुछ सब हो गया, फैमिली मेंबर्स हो।
नहीं ये आईए नंबर 659 में एक डिफेक्ट लगाया है ऑफिस. Proposed legal here of respondent number 1A and 2A are same person. बताइए how will you explain this? बताइए. सप्लीमेंट्री से कैसे एक्सप्लेन होगा? नहीं होगा ना. कोई बात नहीं, अभी आप आराम से ऑफिस नोट पढ़ के समझ के बहस करिएगा नेक्स्ट, बाकी सब बाद में देखेंगे. पोस्ट ऑन 17 नवंबर. ऑर्डर्स का कोई एक अर्जेंट कोई मेंशन कर रहे थे, आप कर रहे थे मेंशन, आपका मैटर है.
Order 41 rule 11 में item 54, it may be taken up day after tomorrow.
क्या होगा?
Admission के लिए and I filed an IA for injunction also.
इतना दिन से तो पेंडिंग है, इसमें
नहीं, but-
टाइम बार्ड है. कौन सा एक टाइम बार्ड?
No, time much.
टाइम बार्ड.
Time 2025. So day after tomorrow, if it's
This has not been issued.
no, judgment of
What's the
reversal.
matter?
Judgment of reversal.
What is the matter?
Suit for declaration of right title interest and for cancellation for deed has been allowed, and on appeal it has been reversed.
It was allowed and then reversed.
Yes.
Cancellation on what ground?
On the admittedly, Your Lordship, the plaintiff purchased the property in 2010. Now the principal defendant, defendant number 1, she filed an application under section 16 of the Bihar Land Reforms Fixation of Ceiling Area and Acquisition of Surplus Land Act for preemption. That proceeding, it was no notices were issued to the plaintiff and order was passed. Pursuant to that order, a sale deed was executed by the defendant number 3 in favor of defendant number 1
By the court.
through court. Now I instituted a suit for declaration of my right title interest and for a declaration that the sale deed is not binding on me. My suit was allowed.
Why you saying it? You are the vendor.
No,
You are
I
the
was the
purchaser.
purchaser. I was
How
the
will
purchaser.
it not bind you?
I
Under
was-
section 16 they have a right. You did not challenge the order of
I did not challenge it, but now there was a my suit was decreed on the ground that no notice was issued to me in that proceeding. irregularity.
How? It has its own remedies.
Now, your leadership will kindly consider the judgment of the Honorable Supreme Court, which has also been relied upon by the relevant trial court also. Leadership will kindly come to.
This is an appealable order, revision lies.
But a suit will also lie.
Suit will also lie challenging the order
A suit
of
for
preemption.
suit for declaration of right title interest.
You see, you are the vendor, you are the purchaser.
Purchase.
Title of the vendor is not in dispute.
No.
There is another sale deed. Cancelling your sale deed. No, there is another sale deed by virtue of section 16.
By virtue of section 16 or yes.
Yes, you are a party in that
Yes.
proceeding.
Yes. No, I was a party, but no notice was issued to me.
Maybe no notice was issued. So there is a remedy under the act. You didn't avail that.
No,
When
I
did
was
you
not
come?
aware. I was not aware of that. I was never aware of that order. Therefore, I instituted a suit for declaration of right title interest.
And did you challenge that order also?
Yes. Your leadership will kindly see the prayer.
ये दिखाइए तो fixation of lands. Where is the judgment of the Supreme Court that
Yes.
the suit is not barred? Like
This has been also relied upon by the Honorable Telangana Trial Court. Para 9 of the judgment is given.
there is an exclusion of jurisdiction.
Yes. I'll just read para 9.
The famous judgment of Dhulabai.
Okay.
Dhulabai's judgment
Yes. There is another judgment of Patna Court full bench.
with regard to this.
That is with respect to the CNT Act. CNT Act is also said.
No, it is not the same. It is not the same. Which is that provision which prohibits the jurisdiction?
Section 43.
Section
43. But it is in prohibition is in relation to matters which has dealt with in that.
In this particular case, the purchaser, the vendor are also party.
Before the
In this case.
LRTC.
In this case.
Yes, yes. They are party.
They are what? The vendor as well as the purchaser are party.
They are party.
Which is that section?
Section 43 is the bar.
Section 43. And what is the ground of your challenge?
Ground of challenge.
Violation of statutory provision?
Apart from that, no, the learned appellate court has held that since section 43 bars jurisdiction of civil court, therefore the suit was not maintainable. Whereas the learned trial court has gone into this issue, verified the proceedings before the LRDC, and had found gross illegality and irregularity. So therefore, even if there is a bar, the civil courts have jurisdiction under section 9.
Once a question of law. Right? उससे रिलेटेड कोई क्वेश्चन ऑफ लॉ ही नहीं बनना।
नहीं DE
E is something else. This is regarding cancellation of CD.
yes, that is also
When you
हाँ,
challenge the order in the civil court, you have challenged the order and the cancellation of CD is consequential.
yes.
Right? The main relief is the order or passed under section 16.
DE
नहीं इतना वेग क्वेश्चन ऑफ लॉ नहीं बनाएंगे आप
अच्छा,
क्वेश्चन ऑफ लॉ ठीक से बना के
परसों रख दिए, कल हम नहीं है, परसों रख दीजिए, कल हम सप्लीमेंट्री फाइल कर देंगे।
The learned counsel for the appellant has submitted that the learned first appellate court has reversed the judgment of the learned trial court, primarily by referring to section 43 of the Bihar Land Reforms fixation of surplus.
Section of ceiling area and acquisition of surf.
पूरा नाम बताइए आपको।
बिहार लैंड रिफॉर्म्स ब्रैकेट में है फिक्सेशन ऑफ सीलिंग एरिया एंड एक्विजिशन ऑफ सरप्लस लैंड ब्रैकेट क्लोज एक्ट 1961.
He submits that by virtue of order passed under section 16, the sale deed was executed, but the statutory provisions were not followed, and the plaintiff claimed title over the property, and also challenged the order under section 16 before the learned civil. However, he seeks settlement. आप एक देकर आइए और ठीक से जजमेंट लेके आइएगा।
जजमेंट
है ना इस वजह
हाँ, ये तो 1970 वाला है और एक फुल बेंच का है हम लोग को पटना
लेके
का।
आइएगा, उसमें लिखा देंगे, ऑर्डर में लिखा देंगे, नोटिस करेंगे और डिसाइड करेंगे। ठीक है, ऑर्डर में लिखाने से ठीक रहता है।
लेट मी डे आफ्टर
पोस्ट डे आफ्टर।
मैं रिक्वेस्ट करता हूँ एडमिशन सीरियल नंबर 33 is for limitation notice. Shashank Sekhi is appearing in this report and we will followed by his consent.
नहीं, he was mentioning it in the morning that he is otherwise busy today. He has mentioned it in the morning.
Yes. Yes, so the day after tomorrow.
आपको नहीं, छुट्टी के
Great
पहले
case
का
के बाद
दिवाली
ही
में
था।
आना आपको।
एक केस के बाद ही तब 25 सीरियल, लेकिन
इसमें क्या है?
लिमिटेशन पर नोटिस वोटिस सर्व हो गए, अदर साइड ऑलरेडी एफआईआर।
और आप
नहीं,
What 34?
कोई बात नहीं सर, अब छुट्टी के बाद करिएगा, हो सकता है आपकी किस्मत में कोई अच्छा बेंच हो।
Serial number
हाँ?
28 and notice will go to limitation. Notice will go to limitation matter.
कौन सा सीरियल नंबर?
28.
बाकी सब क्लियर है?
बाकी
कितना दिन का डिले?
199.
आइए नंबर बताइए।
Yes, sir.
सीरियल नंबर कौन सा?
28.
सीरियल नंबर 28। आइए नंबर बताइए।
Yes.
ऑर्डर 41 रूल 11 में है। ऑर्डर
नहीं, orders में 13234.
13234
25.
ऑफ
25.
देखिए, आई नंबर 13234 ऑफ 25 इन सेकंड अपील नंबर
221 of 2022.
221 of 2022 issue notice to the respondents।
124.
बाकी कौन?
1 2 3 private respondent और 4 number खास number ऑफिसर.
Respond number 1 to 4 for which in the limitation matter being IA number 13234 of 25 for which requisites and the speakers we filed by 29th of
34 में जो राइटर
under
नंबर
speak post
34 में एक तो इग्नोर करवाना था जो डिफेक्ट के लिए, उसमें ऑर्डर्स के लिए रेस्पोंडेंट नंबर 1 कंपनी इसका रिप्रेजेंटेटिव ले लिया है और 2 को वैलिडली सर्व हुआ है और एडमिटेड केस है, इसलिए हम इसको जो से ये करते हैं कि इसको इग्नोर कर दिया जाए। 34
है क्या फाइल? सर छुट्टी बात करिएगा क्या?
ठीक
ठीक।